Evening. I am Kiera Jarman, and welcome to 7501 Dog News. Let's get down to business. Our nation is in a state of emergency as two of the biggest technology companies are at war. Today, we will discuss the ongoing litigation between Apple Incorporated and Samsung Electronics as they battle it out to determine who is at fault for infringing on each other's designs. I have my subject matter experts on the line with us today, Kirsten Nye, Eli Felice, and Carrie Bird, who will join me later on in the segment as our developments unfold. In tonight's special, we will discuss the facts and background necessary to understand this design war, the significance and implication of design patent, the potential unintended consequences and implications, and lastly, the opportunities and risks. So, what are the facts? Back in April 2011, Apple issued a lawsuit against Samsung, accusing the electronic company of infringing on specific design patents found in the iPhone. The amount of damages in a US verdict was the largest design patent infringement jury award of all time. It was actually upwards of $1 billion. So this goes to show that a design patent war like Apple versus Samsung lawsuits have sieged center stage of the modern battle. In addition, it signified that any company must seriously incorporate design patent issue into its intellectual property portfolio. The dispute also revealed an interesting, unclear boundary of design infringement that could impact the level of legal risk for every related industry. Let's look at the first lawsuit. It includes 7 utility patents, 3 design patents, trademarks on multiple iOS system app icons, 6 trade dress registrations on the iPhone, iPod Touch, iPad, and the packaging that it comes in. So Apple is asking Samsung to pay for infringements in the past and stop infringing in the future, permanently forbid Samsung and its various divisions and suppliers from ever using Apple's claimed IP again unauthorized. They also want them to pay for any wrongful profits Samsung might have gained from using Apple's IP, pay for corrective advertising, and of course, they will be responsible for all of their attorney's fees.
So, what's all the fuss about? Well, the products involved in this trial is the iPhone 4, and Samsung says that the iPhone 4 infringes on these particular patents, including Patent 516, which manages the phone's resources and battery by prioritizing the data, and Patent 941, which provides a way to package and transmit data more efficiently. On the flip side, Apple says the Galaxy S, which is in question, infringes on patents 087 and 677, which are the ornamental design of the iPhone. It also says it infringes upon patent 305, which are the rounded square icons on the interface that we've grown to love. So, does Apple have a point?
Now we're going to jump more into patent laws by bringing in my SME expert, Eli Felice. He's worked in the tech business for many years, and he will discuss the significance and implication of design patent and litigation. Eli, are you there?
How's it going? Uh,
Good.
first, first, I wanted to talk about trade dress. I know this was supposed to be a dress. So, in talking about trade dress, what is meant is the phone's look, feel, and software characteristics. When Apple and Samsung began competing and pushing Nokia and BlackBerry out of the market, both of their phones had a very similar look to them externally, a dark face side dominated by mostly the screen, a single action button on the bottom, the user interface being a 4x4 grid with app shortcuts on a touchscreen. You can see the results of the similar starting points even today, as pictured below on this slide. Both phones' latest models exhibit very similar characteristics. Regarding patent laws, there are two primary sources that allowed for this legal dispute to take place. United States Code Title 35 is all the laws pertaining to patents, how to create one, what constitutes infringement in Chapter 3, length of patents for which tech inventions, the length of patents for tech inventions, which tends to be around 20 years, and other such things regarding for patents. Patent laws in the US, when it comes to unfair trade, can also be enforced through the International Trade Commission Section 337. The reason Apple was able to take this legal case worldwide is because of the World Trade Organization's TRIP laws, which is a minimum standard agreement of what constitutes patent laws for all member countries. And this includes Australia, the European Union, Japan, the United Kingdom, the United States, and South Korea, all places where Apple and Samsung had legal battles regarding patents. Back to you, Kara.
Thank you, Eli. Now let's hear from Carrie Bird. Carrie, how are you today?
I'm good. Thanks for having me.
Well, I want you to speak to the audience about the outcomes of the litigation. Was there a winner? And what lessons would you draw from this saga?
Oh, yes. I wish the outcome was that cut and dry. Actually, there were many outcomes from this litigation. Let's look at some highlighted outcomes throughout this 7-year lawsuit. This will help explain how we got to this point for the audience. So the first lawsuit was filed on April 11, 2011. And on the 22nd, Samsung decided to hit Apple with their own lawsuit in Korea, Japan, and Germany, stating Apple violated their patent rights. Piece by piece, the case starts coming together before getting here. On December 17th, Apple was denied permanent sales ban on Samsung product. So what does that mean? It means Samsung can still sell that product that's under investigation, and Apple will have to settle with payments of past damages. But it doesn't end there, Kara. To add more chaos, on October 22nd, 2013, Apple claimed that Samsung intentionally leaked their licensing agreement, and Samsung actually used confidential court documentation as leverage to negotiate terms with other corporations. Samsung denies this report and says it was simply a misunderstanding. I believe this was an attempt to show Apple what this could mean if they allow the courts to decide. They run the risk of court documentation being viewed by the public, risking potential scandals and judgment from the public eye. At the top of the year, they received a court order to try mediation, with both parties agreeing if they cannot come up with a resolution by February 19th, that they will go to trial. Here, by February 14th, both parties couldn't agree on the value of each other's patent. And after years of claims being denied, settlements being made, and of course, scandal, on June 27, 2018, after 7 years, the jury in the U.S. District Court of Northern California ordered Samsung to pay Apple $539 million in damages. To avoid any appeal, the two companies agreed to resolve their differences outside of the court, with the terms of the settlement not being disclosed by the public. So, Kira, earlier you asked, who is the winner and what does this mean for the future? The true winner of this case is Apple, and not just because of the amount awarded in the settlement, but because of what this means for future litigations in the future. Apple set the standard for what companies could sue for. They literally won because Samsung's product had the same look and feel of their products. It's also important for companies to take this case and learn from Apple. You must patent everything and receive registration for every concept you design. Although the look and feel of iPhone have changed over the years since this lawsuit first started, they are still making money off the first iPhone that they no longer sell. This is another example of how Apple is able to lead in the tech world and cripple their main competition, Samsung.
Thank you so much, Carrie. That was great insight. So the litigation was truly global in scope. I want to bring in Kirsten Nye, and can you explain to our viewers why? Why was this such a huge litigation, and where were the most important courtroom battles found?
Thanks for having me, Kira. Happy to share. The litigation was truly global in scope, and between 2011 and 2014, Samsung actually and Apple actually went to battle in 8 different countries outside of the United States. This included Germany, Italy, France, the United Kingdom, the Netherlands, Korea, Japan, and Australia. Japan actually ruled that Samsung did not infringe on any patents, while Germany decided to side with Apple and ban the sale of certain Samsung products that were under consideration. In 2014, the two companies decided to drop all of those lawsuits outside of the United States in a settlement that was not disclosed to the public. We do also want to ask, what is deemed ethical behavior? The biggest issue of this scenario is that there is no reward for companies to behave ethically. The gain of Samsung infringing on the patent rights of Apple, which was much greater than the penalty, making it worth the risk of doing so. The market share that Samsung gained from their products far outweighed any financial burden of a potential lawsuit, and the amount that Samsung would have to pay Apple was very minuscule in comparison to the size and the value of their company. Until there is more significant punishment to discourage companies from doing this, we will unfortunately continue to see this being an ongoing issue. Let's look at the opportunities and risks of this war as well. Because of this verdict, Apple does now have the opportunity to potentially go after other companies for stealing their design. Some risks do include increasing prices for the consumer because of limited availability of product options and disrupting the supply chain of Samsung during these verdicts. I'll pass it back to you, Kira.
Thank you, Kirsten. Well, as we round out this conversation, I want us to look into the future. Eli, I want to pull you back into this conversation. And if you can share with us what the future holds for Apple and Samsung as they move forward, and what can our audience conclude from this conversation today?
Well, thank you, Kara. There were 3 questions that came to mind when thinking about the future. The first question is, how will this case change how the law views patents? And I'd say due to the changing technology, it may be time for the legislature to look into updating the legal code. Most recent updates regarding copyright and intellectual property was the DMCA, and that mostly pertains to artistic works, and that was over 20 years ago. The last attempt to amend Title 35 was in 1994. Regarding other cases now where patents are center stage, there's a case happening as recently as this year regarding the right to repair. Coincidentally, Apple is also at the center of this legal battle. Right to repair is the idea that manufacturers should sell replacement parts as third-party manufacturers, or allow the production of replacement parts to fix broken items that people have. At the moment, the patent allows a monopoly over fixes of new products only to the manufacturer, and that is if they even want to repair it. Apple has been known to recommend buying a new product instead of repairing an old one, should you need a repair. And as for the third question, what does this mean for future collaboration projects? While I think companies may take more into consideration the risks going into a collaborative project, I don't see collaborations going away because of this. Microsoft, IBM, even Apple were all born out of collaboration. If it has anything to do with billionaire companies, most of them are built through collaborative projects. And those are my thoughts. Back to you.
Thank you, Eli. Well, there you have it. Apple won the litigation, and this just goes to show that companies must seriously incorporate design patent issues into their intellectual property portfolio. I would like to thank my guests for joining me today. That's Kirsten Nye, Eli Felice, and Carrie Bird. This has been another primetime special on 7501 Dog News.